Good evening. I'm Sam Kemble with Workforce Delivery Inc. and it's May 8th, 2018. Welcome to the third edition of our Respect in the Workplace series in a post-MeToo environment. Today we will be conducting a partial, if you will, gap analysis of Bill 30 and the Construction Owners Association of Alberta Respect in the Workplace Toolkit. And Bill 30 is a relatively new piece of legislation adopted by the Alberta Government intended to amend two existing pieces of legislation, that being the Occupational Health and Safety Act and the Workers' Compensation Act. And as it relates to OH&S, Bill 30 amends it to further enhance and outline employer, supervisor, and worker responsibilities for ensuring a harassment-free workplace on Alberta work sites. And as it relates to WCB further contemplates the compensability of psychological injury or harm that could arise from a number of areas, but including interpersonal conflict at work, namely in the harassment at work category, which has a clear interface between how employer and management work rules relating to respect in the workplace and anti-harassment policies play out. So that brings us to the Construction Owners Association of Alberta Respect in the Workplace Toolkit. And the reason we selected this is because it was and I think is a best practice. It's widely adopted in the construction industry, and so it's fairly pervasive in Western Canada, not just construction, but industrial, work sites, maintenance, and other by owners and construction providers and other stakeholders and vendors. It's open source, and that's one of the reasons why it's been promulgated. It's designed that employers can take it off the Construction Owners Association of Alberta website and take what they want and leave the rest and create their own work rule. So if it hasn't been adopted writ large, it's in fact at least been the baseline or a starting point for employers across Alberta, many employers across Alberta and in fact Western Canada, for developing their own respect in the workplace work rule. So it's not a bad place to start because it's fairly broadly adopted. The other reason we want to bring it forward is just that the Respect in the Workplace Toolkit is getting a little bit long in the tooth. Much of the formative development of the policy occurred in 2004 to 2007, and then there was an update in 2011 and a reissue from there. So even with that, it's still getting a little bit long in the tooth, and there's been a lot of things that have evolved since it was initially and then reissued in 2011. And changes have occurred of course in employment law jurisprudence, particularly that relates to damage liabilities on the part of employers, and also employer responsibilities as it relates to third parties. There's been some recent case law around that. There's been some ongoing developments in regards to specifically medical evidence and how it has not required to establish mental distress, and that would be in the Schrank case. And anyways, a number of arbitrable and Court of Queen's Bench and Human Rights Tribunal decisions that have an impact and have evolved this area since 2000, certainly since 2011, and most definitely since 2004. So we want to, it's appropriate to do a little bit of a gap analysis to ensure that the Respect in the Workplace Toolkit is keeping up to pace with the common law evolution since its inception. And then in addition to that, there has been as we know, there's a different context in regards to the MeToo and Time's Up movements and an elevated atmosphere, if you will, around the administration of harassment and respect in the workplace, and particularly sexual harassment cases in Canada. And so we should look at the Respect in the Workplace Toolkit within that lens as well, and just note if there's any impacts. And in addition, there's also the with this latest advent, statutory changes, particularly in Alberta, but in other jurisprudences, there's been an increasing adoption of legislating bullying into the legislation, like BC has, etc. But this Bill 30 is the latest and greatest statutory change, which would have some impact in relation to how the Respect in the Workplace Toolkit operates. And again, the importance of this is not only because it was widely adopted, but it's actually become increasingly relied upon by different stakeholders in the industry. And even though the Respect in the Workplace Toolkit was meant to be a best practice, not a minimum standard, it has in a lot of ways become a minimum standard. And that can be witnessed in different contract language or clauses in requests for information from owners to contractors, where owners are telling contractors, if you want to build stuff for us on our project, on our site, then you as a construction provider must have at a minimum the Respect in the Workplace work rule as a standard in protecting your workers and workers on our work sites from harassment. So that's kind of just goes to show how pervasive and widely adopted, which is a really positive thing that the Respect in the Workplace Toolkit has become. In addition, there's been a number of collective agreements, construction agreements, maintenance agreements, and project labor agreements across Western Canada that have adopted the Respect in the Workplace or a similar work rule as an agreed to work rule for administering harassment and interpersonal conflict at work, and as agreed to between the employer and the union. So there's existing contract language that relies on it, and it's just important to make sure that the document that if an employer is applying the Construction Owners Association Respect in the Workplace Toolkit, we just need to make sure that in doing so, that satisfies employers' obligations to current employment law and statutory law. And if it doesn't, we need to just specify where the gaps are and fill in those gaps so that employers are on the right side of the law. So we hope that this is useful to you and valuable. And if you find these valuable, by the way, there's a logo in the bottom right corner of my screen here that you can click and subscribe to our channel to follow our future updates on different employment law and workforce delivery and supply issues that occur in Western Canada. So let's just start by locating the Respect in the Workplace Toolkit. And from its outset, its intention was to go beyond definitions, and it certainly wanted to go beyond legal definitions in 2004, and that was still the case and carried through in its during its reissue in 2011. And basically, it's a work rule that includes a respect and intention to aspire to ensure protections, to motivate employers and parties on a work site to encourage a safe work environment, to respect property, to respect people's privacy, to respect gender differences. And there was a specific attention to that because the policy has always wanted to support initiatives to make the industry more attractive to women, more welcoming to women, and to support women who are engaged on site in their successful career path. Also, the policy respects physical space and belongings, and that would be kind of over and above legislation, certainly. Also, there's a respect for different opinions and different occupations. And those that are familiar with construction trades or industrial sites, they know that the work is divided up into separate trade categories, and there's a lot of different craft and different occupations on site. And sometimes we need to remind ourselves to respect the perspectives and role and contribution of other trades on a site, and also of different labor postures. In addition to that, the Respect in the Workplace model has always wanted to inspire and welcome cultural diversity, and in fact celebrate that. So again, this is just for locating that work rule, at least when it was issued. It's always intended to be, even though it did end up becoming a floor, either by contract or just by contract from owners, or by incorporation into collective agreements. The policy itself was meant to be a best practices, not a minimum practice. But I mean, I think it's important to know when we're holding up this work rule against a minimum standard, that being legislation. And it's just that I think that'll become important as we move further into this discussion. So moving right along, I just want to take a look, whenever you're comparing two different documents that cover the same area, their jurisdictions kind of overlap, in my opinion, it's important to take a look at definitions. So I wanted to start, and let's just start with digging into the definitions afforded in Bill 30 as it relates to how harassment is defined. And we find that in the definition section up on the slide there. And it starts off being a fairly broad definition. Harassment means, which is actually is a very prescriptive way of drafting a definition clause. So harassment means any single incident or repeated incidents of objectionable or unwelcome conduct, comment, bullying, or action by a person that the person knew or ought to have known, ought to reasonably have known, that would cause offense or humiliation to a worker or adversely affect a worker's health and safety, comma, and includes. So it's and includes. And here's where it starts to get, depending on how you interpret this, but you could interpret this to being putting some bookends on what harassment is, with the and includes is prescriptive, and it goes on to say conduct, comment, bullying, or action, and then it goes on to another additional qualifier, because of race, religious belief, colors, physical disability, mental disability, age, ancestry, place of origin, marital status, source of income, family status, gender, gender identity, gender expression, sexual orientation. So let's just start with, we'll stay there with that bullet. That bullet is actually consistent with the definitions of harassment that is found in the Human Rights Act. So this would be harassment, or status harassment, sometimes people call that, being harassment that is in fact already protected by legislation, that being the Human Rights Act, or it's harassment prohibited already by the Human Rights Act. So with that, it would appear that the drafters of the legislation, it appears to me, the drafters of the legislation are tending to, they recognize that they're opening up a Pandora's box here, because this is big, and then they're trying to put some bookends on it in terms of confining it to harassment specifically as defined in the Human Rights Act. And then it goes on to the second bullet, and, so it's and there's additional rider that would also include that harassment can mean or pertain, relate to sexual solicitation or advance, which I think is a reaction to the MeToo Time's Up, at least, movements. But in any event, so the short story is the harassment is as it's defined in the Human Rights Act, and a rider that would include sexual solicitation or sexual advance. And then there's an additional qualifier which we often see in Respect in the Workplace policies, including the COAA Respect in the Workplace policy, just specifying that harassment excludes, or it does not mean, reasonable conduct of an employer or supervisor in respect to the management of the workers on a work site. So my read of this, and I guess it's going to be, I understand there's going to be interpretive bulletins that are released later on, but my read of this, and I think there's probably a couple ways you could read it, but my initial read of it is this may not be as broad a definition as many originally thought. Now, having said that, it's not clear to me how limiting this definition would be sustainable in the long run, especially when it gets into the compensability of psychological harm. And I don't know that WCB will interpret psychological harm arising from harassing conduct, whether it be status or non-status. I don't know that WCB will differentiate between the two when they're contemplating the compensability of a psychological harm brought upon by persistent or an interpersonal conflict at work that would be considered harassment, status or otherwise. So in contrast, the definition of harassment for the Respect in the Workplace Toolkit is very, very broad, and there's very little bookends on it. It just handles it differently. So in the first instance, the word harassment in the Respect in the Workplace Toolkit means something quite different from the word harassment in the Bill 30 legislation. And that's important to note, and maybe it could be a place that an employer may want to be explicit in terms of how it interprets that clause or that policy in relation to Bill 30, so as to not leave it to chance when and if your policy is reviewed by a third party. And we'll get into a little bit more of that in a moment. But just to explain the difference, in the COAA Respect in the Workplace Toolkit, the word harassment is very broad and encompassing, and it just simply means unwelcome verbal or physical conduct which is known or ought to have been known as unwelcome, offensive, demeaning, humiliating, hostile, or embarrassing to a worker or a group of workers. Examples include verbal or physical abuse, threats, derogatory remarks, hazing, jokes, innuendo, taunts, the display of pornographic, racist, or offensive language, practical jokes that result in awkwardness or embarrassment, unwelcome invitations or requests, either indirect or explicit, in any communication medium, intimidation, leering, or other objectionable gestures or condescension that undermines self-confidence, unwanted physical conduct such as touching, patting, pinching, or punching. So that's a very broad definition of harassment. And then the model is, and it's intended to be that way. Again, the Construction Owners Association Respect Toolkit was not intended to be a minimum standard. It was a best practice. So it is broad by design. And then it goes further into categorizing what the COAA Respect in the Workplace Toolkit considers harassment into subcategories, which would include bullying, discrimination. There's actually unprofessional conduct and cultural insensitivity also in there. Now, what's important for us to note here is bullying it's bullying, but would also include non-status harassment. So harassment that's not associated with a protected or prohibited ground under the Human Rights Act. But discrimination in the COAA Respect in the Workplace Toolkit, as issued in 2011, in fact means it equals harassment in the Bill 30 legislation. And one of my recommendations to employers would be to explicitly state that in their administration of complying with Bill 30, or the OH&S and the revised WCB Act as a result, that the employers map the harassment provisions in Bill 30 and OH&S and WCB Act to the discrimination portion of the Respect in the Workplace Toolkit, so as to not leave it to chance. And one of the reasons I say this is just to ensure that, because as an employer you've adopted a better than the minimum standard, but that doesn't necessarily mean that you want third parties to be holding you to a higher standard than you would otherwise be held, especially as it relates to OH&S and WCB. So by being explicit to say that, yes, this is our Respect in the Workplace Toolkit, and the discrimination portion deals with your harassment portion, and that would mean that you're not volunteering for a third party to hold your organization to a higher standard than otherwise would be mandated by the legislation, which we don't quite exactly know where that's going to shake out. So that's just something to think about, or to, I would, if I was an employer, I would strike a committee, or even reference some of this to possibly your Joint Health and Safety Committee, together with some human resource or labor relations expertise, and actually ask them to consider these types of issues and come up with some solutions on how to resolve it. Moving along to WCB. WCB puts forward obligations on the part of employers in 3.1c, that none of the employer's workers are subjected to or participate in harassment or violence at the workplace. So this is an obligation on the part of employers, and it's a two-way obligation. That being that employers need to ensure that none of their employers are being harassed, and also employers need to ensure that none of their employees are harassing. In relation to WCB and supervisors, there's the equivalent obligation on the part of supervisors as there are for employers to ensure that none of the workers under the supervisor's care are subjected to or participate in harassment or violence at the workplace. For workers, there's some additional obligations, and they're additional but obligations personal to the worker. And in the first instance, workers are obliged to refrain from participating in harassment or violence at the workplace. Workers are obliged to report to the employer or supervisor a concern about an unsafe or harmful work site, act that occurs, or condition that has existed. And also the employee has the obligation to cooperate with any person who's exercising a duty imposed by this act, regulations by the OH&S code, and I would take that to mean to include to cooperate with any investigation arising on site in response to a safety issue, including that of harassment. WCB also has rolled in fairly common language in respect to their evidentiary requirements, that being where evidence is in support of opposite sides of an issue are related to a claim for compensation is approximately equal in value, that the issue shall be resolved in favor of the worker. And I think in this context there's going to be some interesting cases that arise out of this, because one question that comes to mind is resolved in favor of which worker, because the WCB has protections in respect to some workers and obligations imposed on other workers to both not participate in and be protected from harassment. So unlike an employer-worker scenario, we're going to be having two workers with where the fact set may be, well, they're going to be presenting about multiple sides to the same story, and it's going to be up to the employer to weigh which evidence is the employer prefers. And where it becomes close, it's going to be interesting to see how this clause operates in practice. I think that's going to cause a lot of consternation and adjudication. So WCB also puts forward a definition, a very explicit definition of the psychological injury, and it again uses that prescriptive term means. Psychological injury means any psychological disorder or condition that meets the diagnostic criteria for a disease or condition that is described in the most recent edition of the Diagnostic and Statistical Manual of Mental Disorders, published by the American Psychiatric Association. So one of the issues is that this flies in the face of recent case law, including case law that has risen to the level of the Supreme Court of Canada, that being in Shrink, where it was clarified that an actual medical diagnostic is not required to establish mental distress that would then result in a tort-like damages on the part of an employer. And in that case, it was, I believe, in response to a wrongful dismissal case. And in order to get into the realm of tort-like damages in that context, there has to be a mental distress established, and then B, that mental distress was caused by the employer. So this definition is going to collide with that. It attempts to put some bookends on it, and it's not clear how this is going to operate in practice. And in addition, and I'm not sure that this is the intention, and I really don't know what the answer is, but I'll just put it out there. Is the intention then, if now that this is an insurable, covered by WCB insurance, is that then put it into the realm where employees cannot sue their employer? So does this in fact restrict employee access to suing employers for damages as a result of mental distress, because it would fall into an otherwise WCB insured category, and thus barring that tort-like damage from consideration by the courts in Alberta? And again, I'm asking that as a question. I do not know what the answer is, but it just puts forward some interesting questions. So the purpose of this discussion was just to get people thinking about the impact of Bill 30 as it relates to the ongoing implementation of an employer anti-harassment or respect in the workplace policy. And there's a few implementation things that need to be considered in terms of aligning definitions between the Act and the policies, putting some definitions on where the Act is covered, and if your workplace policy goes broader than that, then I would recommend being explicit in terms of where your policy is going above and beyond the Act, just to not invite more third-party scrutiny than you're otherwise already obliged to. There's going to be questions on how the evidence is weighed when employers are adjudicating, and then later perhaps WCB is adjudicating worker-to-worker issues that have reasonably equal weighting of evidence, opposing evidence, if you will, in regards to interpersonal conflict, which is very often the case. It's something that happens to employers often, not necessarily something that employers cause, but can't control human behavior, and employers in the respect in the workplace realm, I think we're a little bit more free to afford some more flexibility in addressing these issues. But this added layer is going to be interesting to see how that plays out. There's also going to be some questions as it relates to how the definition of psychological injury is confined to something that's in fact diagnosed, and how is that going to interplay with where courts in Canada are going, including the Supreme Court of Canada, or as it relates to they're not requiring a specific diagnostic for employers to be subjected to tort-like damages. And then further to that, is there perhaps an unintended consequence of this legislation that in fact makes those types of tort-like damages outside of the realm of what employers can sue or be sued for in Alberta, because it's in fact covered by WCB, the no-fault nature of the WCB system. So there's going to be lots of questions. I know there's going to be interpretive bulletins, obviously a more fulsome discussion. I hope this just gets employers thinking about some of the things they may need to consider in implementing this. And again, we hope that this is useful. A lot of this is going to also come into play and further elevate the need for really sound investigative tools and tactics, which again, we are going to cover specifically in a future Respect in the Workplace series. So again, I hope this is useful. I hope we didn't give you too much of a headache, but this stuff is going to be complex, and there's going to be, I think, some one step forward, two step back, hopefully two step forwards, one step back, as the parties figure out where the boundaries are.